This is the part 3 of our discussion on the rules of procedure for environmental cases. Just a quick recap, we said that for your environmental case, the first step is that the plaintiff will file a verified complaint, or the plaintiff can also file a verified complaint together with a prayer for the issuance of an environmental protection order. We already answered who may file or who is your plaintiff. Just remember again your citizen suit, and then we also answered in what court you are going to file your environmental case, that is your MTC or RTC, and of course the rule on filing fees. After the filing of the verified complaint, what will happen next? Ang bola nasa korte na. So the court will issue now your summons. As far as your summons is concerned, we studied already who may serve the summons and how is the service of summons effected. After the service of summons, what will happen next? Ang bola ngayon nasa kay defendant na. So, let's compare. If you are in an ordinary civil case, pag nakatanggap ka ng isang summons, what are your options? Your option is, before you are going to file your answer, you have the option to file a motion to dismiss. Can you file a motion to dismiss in an environmental case? The answer is no. That is not allowed. That is a prohibited pleading. Section 2 of your Rule 2 of the Rules of Procedure for Environmental Cases is very clear that your motion to dismiss is not allowed. It is a prohibited motion. In fact, pag tiningnan mo, lahat ng motion to dismiss the complaint not allowed. And if you're going to compare that to your Rules of Civil Procedure under the 2019 amendments, is it the same? More or less, the same. Kasi motion to dismiss is also not allowed under Rule 15 of your Section 12, but there is an exception. If you have these 4 grounds, then you can file a motion to dismiss in your ordinary civil case. And if we are going to compare it further to your rule on summary procedure, ang motion to dismiss is also not allowed except on the ground of lack of jurisdiction over the subject matter or the failure to comply with the barangay requirement. So going back to your environmental cases, sinabi natin lahat ng motion to dismiss, walang exception, not allowed. So if you can see in the complaint that the court really has no jurisdiction, then what can you do, defendant? What the defendant can do is just to file his verified answer. And in his verified answer, he is going to plead that as a defense. If you read your Section 14 of your Rule 2, affirmative and special defenses not pleaded shall be deemed waived except lack of jurisdiction. So, kung hindi mo nga na-i-plea pa rin yan na walang jurisdiction ang court, pwede mo pa rin habulin because that is not considered waived. So again, in your environmental case, defendant is not allowed to file a motion to dismiss. How about a motion for a bill of particulars? That is also not allowed. Your motion for a bill of particulars is a prohibited motion that is not allowed under the Rules of Procedure for Environmental Cases. That is also true when you talk about the rule on summary procedure. How about in your Rules of Civil Procedure? Kung merong sasagot sa inyo ng that is also a prohibited motion, yan talaga yung time na mag-walk out yung professor nyo, especially if you are in your 4th year review, because obviously you did not read your Rule 12, your Bill of Particulars. Pag malabo ang isang pleading, the Rules of Civil Procedure allows you to file a motion for a Bill of Particulars. So motion to dismiss as well as your motion for a Bill of Particulars, they are not allowed in your environmental case. How about a motion for extension of time to file answer? Then this is allowed. This is not prohibited. So motion for extension of time to file pleadings is a prohibited motion. But if the motion that you are going to file is a motion for extension of time to file answer, then that is allowed as long as the extension that you are requesting will not exceed 15 days. How about under the Rules of Civil Procedure sa 2019 amendments? The same. Motion for extension of time to file pleadings, that is also not allowed. But if you're going to file a motion for extension of time to file an answer, then that is allowed. Read your section 11 of your Rule 11. A defendant may, for meritorious reasons, be granted an additional period of not more than 30 calendar days to file an answer. But just take note that he is only allowed to file one motion for extension of time to file an answer. And if you're going to compare that to your rule on summary procedure, sa rule on summary procedure, walang exception. Lahat ng motion for extension of time, not allowed, prohibited. So aside from motion for extension of time to file an answer, what else can the defendant file? The defendant can file his verified answer or verified answer with cross-claim or compulsory counterclaim. So for your answer, take note that you need to file this within 15 days from the receipt of the summons. And take note that the law requires the defendant to file a verified answer. And in your verified answer, include already the affidavits of witnesses, if there are reports, studies of experts, at lahat ng ebidensya mo, isama mo na. And if you have affirmative defenses, if you have special defenses, then include it also. You plead that one because if otherwise, it shall be deemed waived. And again, that is except lack of jurisdiction. Take note also that you can file a verified answer with cross-claim or compulsory counterclaim. That is allowed. Section 1 of your Rule 2, pleadings and motions that may be filed are answer which may include compulsory counterclaim and cross-claim. Kasi pag hindi mo na yan na isama, what will happen? Then they shall be considered barred. So the period to file an answer in your environmental case is 15 days. In your ordinary civil case, general rule is 30 days. And in your summary procedure, that is 10 days. Take note that in your environmental case, you can file a motion for extension of time to file an answer as long as the period will not exceed 15 days. That is also true when you talk about your ordinary civil case. One time, pwede kang mag-file ng motion for extension of time to file an answer, but just take note that the period should not exceed 30 days. How about in your summary procedure? Bawal ang lahat ng motion for extension of time. So after the defendant files his verified answer, what is the next step? Can plaintiff file now his reply? Answer is no, because that is a prohibited pleading. That is very clear according to your section 2 of your Rule 2. In fact, reply and rejoinder are not allowed. How about if ang final ni defendant is a verified answer with cross-claim or compulsory counterclaim? Pwede bang sumagot si plaintiff? Answer is definitely yes. In fact, ang sinasabi ng rules, you file your answer within 10 days from its service. So how about in instances wherein the defendant did not file an answer? Can you plaintiff file a motion to declare the defendant in default? Answer is no. You are not allowed to file a motion to declare the defendant in default. That is a prohibited motion. So ano ngayon ang gagawin mo, plaintiff? Since hindi ka pala pwedeng mag-file ng motion na yan, Huwag kang mangamba, huwag kang mag-alala. Because if you're going to read your section 15 of your Rule 2, it is the court which shall declare the defendant in default. And all that you need to do, plaintiff, is just file a motion that the court will receive your evidence ex parte and it will render judgment based on the evidence and your prayer. So, in your environmental case, can there be a party aside from your plaintiff and defendant? Let's call him the third person. Scenario number 1, can the defendant file a third-party complaint? Ano ba ulit yung third-party complaint? Section 11 of your Rule 6 sa Rules of Civil Procedure. It is a claim that a defending party may, with leave of court, file against a person who is not a party to the action for contribution, indemnity, subrogation, or any other relief. So, can he file a third-party complaint? Answer is no. That is not also allowed. That is a prohibited pleading. So, question, can a third person come in an environmental case where the case is already pending? Answer is definitely yes. Because if you are going to read section 1 of your Rule 2, aside from complaint and answer, motion for intervention is also allowed. That is very clear. And again, what is the nature of your intervention? Diba ang intervention, that is a remedy to a third person or a remedy to a third party, and that third party is not originally pleaded in a proceeding, but he becomes a litigant, and the purpose is to protect her right or his right or interest that may be affected by the proceedings. Kaya pwedeng pumasok ang third person as long as that third person has interest or right in the proceedings. So in summary, plaintiff will file a verified complaint or a verified complaint with a prayer for the issuance of a TPO, and then the court will issue summons, and then defendant is not allowed to file a motion to dismiss because that is prohibited. He is also not allowed to file a motion for a bill of particulars. He cannot also file a third-party complaint against a third person. But defendant is allowed to file a motion for extension of time to file his answer as long as the extension will not exceed 15 days. What else can he file? Then he should file his verified answer or verified answer with compulsory counterclaim. Take note ha, compulsory lamang ang pwede, hindi ang permissive. Or he can file a verified answer with cross-claim. And in that case, si plaintiff wala siyang gagawin because plaintiff is not allowed to file a reply, and rejoinder is also included. But if there is a verified answer with cross-claim or compulsory counterclaim, then plaintiff is allowed to answer, and the period is 10 days. Kung hindi naman sumagot si defendant, then plaintiff is not allowed to declare the defendant in default. Hintayin niya ang court ang mag-declare kay defendant in default. At kung meron namang third person na gustong pumasok sa pending case, then he is allowed to file a motion for intervention. Take note that in your environmental case, motion for discovery is allowed. Your motion for discovery is allowed. That is very clear according to your section 1 of your Rule 2. Aside from your complaint, answer, motion for intervention, then motion for discovery is allowed. In fact, that is encouraged. If you read your section 13 of your Rule 2, ano ang nakasulat dun sa summons pag binigay yun kay defendant? Aside from telling the defendant in the summons that he has 15 days to file his answer, the summons is also very clear that he has 15 days to avail of Rule 25, Rule 26, Rule 23, and Rule 27 and 28. So your motion for discovery is very much encouraged in your environmental case.